The 14th Amendment of the United States Constitution states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. As expected, this clause is pivotal to the rights of American citizens and the focus of many Supreme Court cases. Throughout the years, the court has formulated a three-tiered system of analysis to evaluate and scrutinize such cases. Equality does not always mean true equal treatment for all. There are some instances where distinctions need to be made. Such examples include voting rights, driving rights, and drinking rights. This distinction comes into play with the Equal Protection Clause court cases and the three-tiered level of scrutiny utilized to assess these cases. The three levels consist of rational bias review, intermediate scrutiny, and strict scrutiny. All classifications that do not qualify as suspect or quasi-suspect will be determined under the lowest level, the rational bias test. In order for a challenged law to be upheld under this test, the state must prove that the classification is rationally related to any legitimate interest of the state. Strict scrutiny is applied to those that qualify as suspect qualifications, which include race, religion, national origin, voting, and other fundamental rights. As the name implies, this test is very strict and requires the state to show not only that the classification in question serves a compelling state interest, but also that said classification is necessary to serve said interest. In the middle, we have intermediate scrutiny, which is applied to quasi-suspect classifications such as gender. Under this review, the classification in question must serve important governmental objectives and be substantially related to achieving those objectives. In 1982, the terminology exceedingly persuasive justification would be added to the standard. It is under this more heightened form of scrutiny, sometimes referred to as intermediate, that the case of United States versus Virginia would be decided under. On November 11, 1839, the Virginia Military Institute raised the state flag of Virginia as 23 men signed their names to the register, becoming the first cadets of the Virginia Military Institute. Originally founded as a school to train the young militiamen charged with guarding the Lexington Arsenal, VMI would eventually become one of the most prestigious military educations offered. The original mission of the school was to educate militiamen and produce citizen soldiers, those men who were not professional soldiers but would leave their civilian lives and become temporary members of a military force when the exigencies of the times necessitate their doing so. In order to train said citizen soldiers, new recruits are put through a system referred to as the rat line, a 7-month period of deliberately overwhelming physical and mental leveling process intended to create a sense of bonding and equality among the cadets.
On your marks, get set. Go, get up and right out, get up and right out. I know you go faster, let's go, be intense. You push to the team, you push to the team. We push, let's go, up, down, let's go.
Get up right now, push harder.
You complete the exercise as a team. Let's do it together. Perfect. Keep going. Keep going. Keep going. Keep going. Motivate. Keep going. Keep working. Don't quit.
In order to create the sense of equality and true bonding, all cadets live in the barracks on post, which include the barest and simplest of environments. The barracks lack all luxury and privacy, including the lack of door locks and a complete windowed back wall. Cadets experience strict, regimented programs to include demanding classes, military drills, and the adversative system of physical exercise and mental stress, known as the RAT line. VMI creates a sense of community and fraternity, a true all-male bonding educational experience. Women were continually excluded from this environment based on the ideals of fraternity and male bonding. The presence of women would not only deteriorate this system, but render it completely null and void. Women were to be protected, not excelling at the true test of maleness. In just 2 years, from 1988 to 1990, VMI received over 350 requests for admission from female applicants. Women wanted the unique and exceptional education offered that was unavailable anywhere else in the state. One of these rejected applicants, whose identity is still protected today, filed a complaint with the United States Justice Department based on gender discrimination and her rejection to be admitted to the Virginia Military Institute. The case would journey through several levels, including multiple appeals. In June 1991, Federal Judge Kaiser ruled that VMI's male admissions policy was fully justified based on the merits of single-sex education, stating that, "I find that both VMI's single-sex status and its distinctive educational method represent legitimate contributions to diversity in the Virginia higher education system, and that excluding women is substantially related to this mission." Disappointed with the case being portrayed as against single-sex education as opposed to gender discrimination, the Justice Department appealed. The Fourth Circuit Court agreed with District Court regarding the uniqueness of Virginia Military Institute and justifying the all-male policy. However, while single-sex education and diversity of educational options may classify as a legitimate state objective, the court ruled that Virginia and VMI did not establish a sufficient justification for the exclusion of women. This insufficient justification was based on the ruling that single-sex educational institutions must do more than favor one gender. The court provided VMI with 3 unfavorable options. 1. Admit women students. 2. Become a private university and give up federal funding. Or 3. Establish a separate and equal program designed specifically for women. Opting for the least objectionable option, VMI began to create a parallel women's program with the help of neighboring Mary Baldwin College. This program would be known as the Virginia Women's Institute for Leadership, or VWIL. The supposed parallel institute was in truth an insult. These young women would not be subject to the extreme adversative environment in which VMI was known for, nor would they have the same quality of education and amenities provided to the cadets at VMI. However, the courts approved the Women's Institute, and again, the government appealed. On January 17, 1996, the United States Supreme Court began hearing oral arguments in the long battle between the United States and the Commonwealth of Virginia. On June 26, 1996, in a 7-1 decision, the Supreme Court ruled that Virginia Military Institute's admissions policy was in fact unconstitutional, overruling and reversing several lower courts' opinions and judgments. This declaration was founded on two violations: the violation of excluding women and the violation of the proposed remedy, Virginia Women's Institute of Leadership. There remains debate and confusion regarding this case, mainly revolving around the level of scrutiny utilized. Some opponents state the case raised the standard for gender cases from intermediate scrutiny to strict scrutiny. However, this issue was addressed both within the hearings and the opinion.
We have two separate questions, I think. One, whether the original finding of the lower courts that there was an equal protection violation here of the Constitution for Virginia to have VMI but no comparable program for women, whether that was a correct determination. And secondly, I think we have to decide whether Virginia's proposed remedy of the development of the Mary Baldwin College program is constitutionally adequate as a remedy. And the discussion thus far doesn't really direct us to either of those questions. And I noticed that in your brief, the Solicitor General urges the court to adopt the highest standard of strict scrutiny to decide this case. Does your case depend on that?
No.
Can it be decided, as the lower courts did, on the basis of intermediate scrutiny, as the court has done in the past?
Yes, absolutely.
Well, why is this case singled out then for urging us to adopt some different standard? What advantage is there?
The court, just as kind of the court has said repeatedly, I think on 5 different occasions over the last 10 years or so, that the question of the standard to be applied to gender discrimination is an open question. And so we thought that the question might come up of asking us what we thought the right standard is.
Well, it's not exactly an open question in the sense that the court has decided a number of cases.
Well, whether the court has decided
applying a sort of intermediate scrutiny, and if you look at Mississippi University for Women versus Hogan, the court certainly tried to articulate a standard.
Craig versus Florence, they said that was the standard.
That's right. But since then, the court has said that it's an open question whether there should be a higher level of scrutiny.
After review, it appears clear that the court maintained the standard of review and applied intermediate scrutiny in this case. However, I'm not sure the standard truly matters. As Justice O'Connor pointed out, the case could be easily decided and ruled under intermediate scrutiny. The outcome is what truly matters. Upon the ruling of the court, VMI began to implement a program to begin accepting women the next school term. In the fall of 1997, women were admitted into the rat line and unsurprisingly succeeded. Within only a few years, VMI would see women cadets in leadership positions and succeeding within the adversative system. Women can succeed at the same task as men.